All right, good morning, everyone. I'm just going to give everybody a minute to get out of the waiting room before we get started. If you're just joining, I'm giving everybody a minute to get out of the waiting room before we get started. All right, thank you for joining us this morning as we talk about what the Supreme Court of the United States said just last week about separating sports by biological sex. The Supreme Court affirmed separating sports by biological sex, and we'll be discussing what comes next for schools and families. Before I hop in, I wanted to talk a little bit about what WILL is. So, the Wisconsin Institute for Law and Liberty, or WILL, is a nonprofit law and policy center based in Milwaukee, Wisconsin. And through litigation, education, and participation in public discourse, we work to advance limited government, free speech, transparency, and education reform. We provide timely and comprehensive policy research to advance education reform, election reform, economic freedom, and policies to advance limited government. So today I have our managing vice president and deputy counsel joining me, and he's going to give us an overview about West Virginia et al. Versus B.P.J., what it said, and answer some of the common questions that we've been getting about the case. So Dan, I'll turn it over to you.
Yeah, thank you, Lauren. So this case was decided June 30th, 2026. It is styled as West Virginia versus B.P.J. And what is this case about? So let's start with B.P.J. B.P.J. is a biological male who goes by the name of Becky Pepper Jackson. He competed in high school athletics against girls in West Virginia. This year, he placed third place in girls shot put, throwing 34 feet at the state championship. Just for some perspective, at that same track meet, the boy who was in last place in the boys section threw 41 feet, so 7 feet more than BPJ. Uh, BPJ would actually have never made the state championship as a boy. And in fact, he took away third place at the state track meet from his own, uh, uh, his own teammate, who was named Isabella, who would have got third place. But she did not because BPJ, a boy, took the spot away from her. Another interesting fact about BPJ is that attorneys at Alliance Defending Freedom are now representing a teammate of BPJ who has claimed that BPJ sexually harassed her. The other plaintiff in the case was a man named Lindsay Hecox, who was a biological male who ran cross country and competed in soccer at Boise State University in Idaho. Uh, these cases came about because Idaho and West Virginia passed state laws banning biological boys from competing on female designated sports teams. In total, 27 states have now issued several these similar bans prohibiting males from competing on girls' teams. Wisconsin is not one of those states. So we are one of the 23 states that does not ban boys from participating on girls' teams. BPJ and Hecox sued to challenge these state bans in West Virginia and Idaho. They claimed that they violated Title IX, which I'll talk about in a moment, and also the Equal Protection Clause of the 14th Amendment. Although they initially won at the circuit court or at the Court of Appeals and the lower courts, the Supreme Court reversed and ruled for the states. The Supreme Court upheld the bans for West Virginia and Idaho, and by extension, the bans from the 27 other states. So there were two parts to this ruling. The first was under Title IX. So what is Title IX? Title IX is a federal law that was passed by Congress that prohibits sex discrimination in any educational program that receives federal funds. This law was passed in 1972. Soon after the law was passed, the agency in charge of administering this statute passed regulations, and the regulations themselves say that equal athletic opportunity for members of both sexes is guaranteed. The regulations also authorized, quote, separate teams for members of each sex. So right in the regulations interpreting the law, separate sex teams or sex segregated teams are actually permitted. The Supreme Court held in this case, West Virginia versus B.P.J., that under Title IX, the word sex means biological sex. And the law allows for segregation of sexes based on the inherent physical differences between men and women. Now, B.P.J. had argued that he had been taking puberty blockers, and therefore he earned something of a good faith exception to this general rule that allows for the segregation of sexes. The court rejected this under Title IX and said Title IX has no exceptions for puberty blockers or transgender athletes. It simply allows for the segregation of sports by sex, and therefore those bans in the 27 states were upheld under Title IX. This portion of the opinion was 9-0. It was unanimous. Title IX, all the justices agreed that Title IX, the federal law that Congress passed in 1972 and then was amended in 1975, does permit sex segregation in sports teams. Now, the second part of the case was about the Equal Protection Clause of the 14th Amendment. The Constitution, as interpreted by the U.S. Supreme Court, prohibits sex discrimination unless the government has an important reason and the rules that the government makes are substantially related to those reasons. In other words, if you want to separate or segregate sex by sex in your state, you've got to have a good reason to do it, and it must make sense. That's the standard that the court applies to any case in which women and men are separated or segregated or categorized differently. You have to have a good reason, and it's got to make sense. By contrast, in racial discrimination, there's a standard imposed called strict scrutiny, which says the government can almost never discriminate based on race. Sex is a lower standard, and the government can treat men and women differently based on sex, as long as there's a good reason that makes sense. The court here held there is a good reason. There's actually two good reasons why men and women should be separated in athletic competitions. Number one is safety, and number two is competitive advantage. The court said that biological differences are important, and they do, in fact, make a difference. The court then ruled that it doesn't have to decide this equal protection challenge in a case-by-case manner. In other words, the court doesn't have to decide, do certain boys actually not pose a safety risk to girls? Are some boys actually not advantaged competitively? The court said it doesn't need to decide this case by case. It can have a broad rule that says sex separation is permitted in athletics under the Constitution. This part of the decision was 6-3, and the dissents did not necessarily disagree, but said that there should be case-by-case determinations. So transgender athletes should be able to come to court and say, well, in my case, I do not pose a competitive disadvantage, or in my case, I am not particularly dangerous to the other girls. And so that's what the dissent would have held, and that position was rejected by the Supreme Court majority. The court also confirmed that this was not discrimination against transgender individuals. It was like in the case of U.S. versus Grimetti, which was from last year, which talked about a state ban on transgender medical procedures for minors, that it was a categorization based on sex, not based on transgender status. So this case presents two unanswered questions in my mind, and two questions that are going to be going forward. So now we understand that states can separate the sexes in athletic competitions. It does not violate Title IX and does not violate the Constitution to separate the sexes. So, unanswered question number one, is bathroom segregation allowed? Does this apply to bathrooms and locker rooms? Our view is probably yes, that there's no material difference or there are minor material differences between the segregation of sports teams and the segregations of bathrooms, locker rooms. But, and this is the big issue right now, in the Seventh Circuit Court of Appeals, which Wisconsin is part of, the controlling decision is called Whitaker versus Kenosha. This is a 2017 case that says that schools cannot force segregation based on biological sex. That is the controlling law in the circuit. The Court of Appeals held the same in a case called AC versus Martinsville in 2023. There is one pending case, though, that will probably overrule those precedents. It's called Jane Doe versus McGuanago, and it is pending in front of Judge Edelman in Milwaukee Federal Court. And just a few days ago, Judge Edelman ordered the parties to brief whether West Virginia versus B.P.J. essentially has overruled Whitaker in the Martinsville case. He's ordered supplemental briefing that's supposed to happen in the next few days. And so that may be the vehicle to make sure that in Wisconsin, bathrooms can be sex separated, and there's nothing to prevent that sex separation. We think that the reasoning is going to basically go like this. If enforcing sex separation in sports is not a violation of Title IX or equal protection, then enforcing sex separation in bathrooms and locker rooms is also not a violation. The interests are the same. Safety was an interest for the government in the sporting contest, and safety is certainly an interest in the bathroom and locker room context. There's one interest that the Supreme Court did not mention that has risen, that comes up in the bathroom and locker room case, and that's the issue of privacy. The Supreme Court did not mention the word privacy. It did not say that that was a compelling government interest. So that will be a further point for us to litigate, is to ensure that privacy is also an interest that a school board has when they're separating the sexes in bathrooms and locker rooms. So that's unanswered question number one, bathrooms and locker rooms. Unanswered question number two is sex segregation actually mandatory? If schools don't violate a transgender student's rights under Title IX or the Equal Protection, if they segregate, the opposite question is, do schools violate the rights of female students when they refuse sex segregation? In other words, must schools segregate the sexes in bathrooms, locker rooms, and sports to protect the rights of girls under Title IX and Equal Protection? We say yes. We filed a case, which is pending in federal court in Wisconsin, called New Richmond Parents for Strong Schools versus the School District of New Richmond. The school district there allows boys in the girls' bathrooms. The girls in our case are alleging a violation of Title IX and equal protection. They're saying sex discrimination, and we're also arguing privacy rights are violated under the Constitution. And we hope that case is a case to identify that under Title IX, if you are giving a right, if you are giving a right to a transgender student to be in a girl's space like a bathroom, that the girls also have privacy rights and that they can't be treated differently than boys. So in the case of New Richmond, the girls are bearing the burden of having to deal with an opposite sex person in the bathroom. Boys don't have to deal with that burden. The girls are the ones that have to go around the schools and find the single stall bathrooms so that they can have privacy. Boys do not have to do the same thing. We're saying that is sex discrimination under Title IX because boys and girls are being treated differently without any good reason. And also, it violates privacy rights and sex discrimination rights under the Constitution. So that case is pending. We should hopefully have a decision perhaps in the next year or so on that. And there will probably be other cases pending on that issue, the must issue. Must schools segregate in order to protect the rights of female students? So those are two issues that our schools are facing. And so, now the question is, what should school districts do? What policies should parents advocate for to school districts? And so I'll turn it over to Lauren to talk about our recommendations as far as policies and what's next for parents and school boards.
Yes, thank you, Dan. And I should have mentioned this at the beginning, so I'm sorry about that. But at any time during the presentation, please feel free to use the Q&A function. Type any questions you have in the chat about the case or about the model policy that I'm about to go over. And at the end, we will leave some time to answer those questions. So, the Wisconsin Institute for Law and Liberty has many model policies for school boards. This model policy that I'm about to talk about, which is a way for schools to separate sports by biological sex, is one of 49 model policies that we offer. Most of our model policies have to do with good governance, parental rights, and transparency on a wide host of issues. And you'll see that all of our model policies are available online at www.schoolboardpolicies.org. The girls' sports model policy that I'm about to go over today will be emailed to you either later today or tomorrow, along with a recording of this webinar for your consideration for your school, your community, if you're a parent, or for your district if you are a school board member. So, Will has created a model policy based on this decision that allows schools to separate athletics by biological sex. Obviously, this is something that the Supreme Court has said is constitutional if a school district wants to do it. And I'll talk about this a little bit more in depth in a couple slides, but as Dan mentioned, there are over 27 states that have enacted laws or regulations mandating that school districts separate their sports based on biological sex. However, if your state is a state that is one that doesn't have a law that governs whether or not you must separate sports by biological sex, then it is up to the discretion of your school whether or not you want to separate sports by biological sex. Very specifically, in the opinion from West Virginia versus B.P.J., the question was whether schools can separate sports by biological sex. So that's something I want you to keep in mind as I go through this policy. Just because there isn't a law in Wisconsin or the other several other states that haven't addressed this yet, that doesn't mean that this policy can't apply to you or your district. I want to briefly go over the definitions that are included in our model policy. And I will talk about the executive order in a moment here in more depth. But there was an executive order from January of 2025, just after the new administration took over, that talks about protecting women and girls from gender ideology, and that includes in sports. In that executive order, they give definitions of what this administration considers sex, women, men, female, and male. So those are the definitions that we also have used in our model policy. And you can see those definitions on your screen. That's a screenshot directly from the executive order. So, one of the biggest aspects of our model policy is a requirement that school boards separate their teams based on sex. Every single team has to have one of the following designations. It's either a men, boys, or male team, a women, girls, or female team, or a co-ed or mixed team that includes both males and females. And the reason for this is that this matters when we talk about who can be on these teams. So, for women's, girls, and female teams, it's very simple. Only student athletes whose biological sex is female can participate on those teams. I have on here, as originally indicated on their birth certificate. This is something I'll get into in a second, as we kind of talk about the mechanics of how schools can ensure that they're actually separating their teams based on biological sex. But this one is easy. Women, girls, female teams, only student athletes whose biological sex is female. A little bit more complicated, but for men's, boys, and male teams, either student athletes whose biological sex is male, or if the district offers a team for men, but not one for women, and these women have previously, their opportunities have previously been limited, then women, girls, or females may try out for the available team unless it is a contact sport. That section specifically comes from the implementing regulations of Title IX. It is available in CFR 106. And that specifically talks about the fact that women and girls may be allowed to have the opportunity to try out for boys' teams, again, if their opportunities have previously been limited and it is not a contact sport. Those contact sports are defined in federal law as well. So let's talk about compliance because this is one of the biggest issues that we've heard about as even state law has been attempted to be changed. And in these 27 states that we're talking about that have laws on this, this is one of the biggest, toughest pieces that practically government entities like schools will have to deal with. So in general, our model policy gives three options for the school board to decide how they want to handle verifying biological sex. The first is to require the parent or student athlete to affirm the team that they are registering for is the team that matches their biological sex. This would just be theoretically a checkbox or a yes/no question. Then, if there are any issues later on, we have a dispute resolution process. Should a student or parent not be truthful when they are affirming that they are registering for the team that matches their biological sex? But this is the least administrative burdensome method. It wouldn't require parents to produce a birth certificate every season or at all, hopefully. And it would limit the amount of administrative time checking for biological sex of every single athlete. But if a school wanted to take a more stringent approach, or if they have birth certificates already on file, we have options two or three. Schools could require proof of biological sex at sports registration, which could include producing a birth certificate or other documentation that indicates biological sex, or require proof of biological sex during sports registration if it's the first season of a student participating for a male or a female team. So a student has to produce it just once, and then they don't have to do that again every single season if they stay on the same designated team. So if they're a female and they produce a birth certificate that says they're a female, and then the next year they go out for the girls' swim team again, they wouldn't have to produce their birth certificate again. So again, we provided a couple different options for schools because there's different ways that this can be handled, and I think it offers school boards a little bit of latitude to determine what is most appropriate for their district. But, and this is a question we got a lot, what if the birth certificate has been changed? In many states, you can actually change the sex marker on the birth certificate. And this is a concern that a lot of people have when these laws are being drafted and passed is, okay, well, if everything is based on the birth certificate, but the birth certificate can be changed, how can that be the document that we're going to base biological sex on? So, for our model policy, we say that if changes have been made to the sex marker on the student's birth certificate or other documents, that amended document may not be used to determine eligibility. They will have to produce other documentation for the school. And if changes are not disclosed, that the student athlete has registered or has been playing on a team that does not match their original sex listed on his or her birth certificate or other document, then that student will be prohibited from participating on any teams in the future. So, for example, say your school district requires proof of biological sex at sports registration and a student or their parent produces a birth certificate that says that they are a female athlete. If there have been changes that have been made to that birth certificate and it comes out later that that is the case, then the student would be prohibited from competing on that sports team in the future. So that's kind of the two-piece compliance here. First is either having parents or students affirm that their gender identity matches, or their gender identity, their sex matches their the designated team, or they require proof, and they also are not allowed to produce documents that have been changed, that have changed that biological sex marker, and they are required to disclose changes. So we also have a dispute resolution section. And again, this is to deal with circumstances as they arise. We hope that with this Supreme Court decision and with this policy, that you will not have to deal with disputes often, that this will be a pretty straightforward process. But we did want to include something so that you, as school board members, or you, as parents, are not scrambling to figure out what to do should the policy not go to plan. So, any parent under our model policy or student athlete may dispute participation of any other student athlete. So, this dispute does not have to be about the parent's own child nor the student athlete's own eligibility. Then, once a complaint is made, the athletic director shall review the complaint and make a determination based on the information that they've gathered. And our model policy goes through specific criteria that the athletic director must take into consideration, like medical documents, like the birth certificate, like conversations with the student athlete and parents and coaches. Also, the athletic director has the ability to make an interim decision. So, if they're not able to get through all of those interviews or all of those documents prior to a decision needing to be made, they can make one before the final determination. And then finally, after the athletic director comes to determination on eligibility, that determination may be appealed to the school board for a final determination if the parent or student athlete, or complainant if neither the parent or student athlete disagrees with the decision from the athletic director. And there's a couple reasons to include a dispute resolution clause like this. Again, you don't want to be scrambling if and when something comes up. But with situations like this, there may be times where either people are not entirely honest when they're completing their sports registration, or there are situations where there truly are genetic conditions that need to be considered, in which case there is a process to handle that and to do that. So we have a couple additional considerations to keep in mind. We've mentioned this 27 state statement a couple times. If your school district is in any of the following states, you may be required to separate sports teams based on biological sex. So, as Dan mentioned when he was explaining in the opinion of West Virginia versus B.P.J., the question of whether schools may separate sports based on biological sex was answered, but not whether they must separate sports based on biological sex. However, if you are in one of these 27 or 29, which I'll get to in a second, states, then you may be actually required to adopt something like Will's model policy here and separate your sports based on biological sex. So there's actually 29 states on the screen here. 27 of them have state laws that are actually in statute that say that schools must separate sports based on biological sex, and you can see those code provisions there if you're in one of those states. However, there are two states where regulations dictate that they must separate sports by biological sex at this time, and that's Alaska and Virginia. So Alaska's comes from their administrative code, and it's more of an implementing provision than anything else. And that talks about the separation of biological sex. And then we have Virginia, which is a really interesting state. Obviously, it has a very Democratic governor now, but they have a law that specifically requires schools to adopt model policies that their Department of Education comes out with as it pertains to transgender students or athletes or what have you. And the model policy that is most current or most up to date in Virginia does require schools to separate sports by biological sex. So we have those 29 states that have those very like strong, intact, they're in the statute laws that do require schools to separate sports teams based on biological sex. And then we have those two other states that have their implementing provisions. Obviously, because these are state laws, they are subject to change, so always consult with your school district attorney. But I did just want to flag and leave the screen up for a second. All of those states. So if you are in any of those states, then you are on notice that you may be required. Instead of it being a may, it's a must. But we also have the flip side of this, which is if your school district is in a state with an anti-discrimination law that includes gender identity, you should check with your attorney or you can call Will. I'll have our contact information at the end of this presentation to talk about whether or not you can adopt this model policy. So I put up a couple examples. This is not an exhaustive list of all the states that have anti-discrimination laws for educational settings. But for example, in California, they have a law that says that you cannot discriminate based on the basis of gender identity in educational settings. So there may be people in California that argue that because you cannot discriminate on the basis of gender identity, you wouldn't be able to separate sports by biological sex. Obviously, this is a problematic take for a couple reasons because at this point there's now federal law that is in tension with state law, which is why I said you should talk to your attorney or call us about it. Minnesota is also on the screen there. They have an anti-discrimination law. They are right next to our neighbors. I have Colorado on the screen. I know there are others on the East Coast that have these anti-discrimination laws. But this is also something to be aware of. If you have an anti-discrimination law that affects educational settings that include gender identity, you may want to just check with an attorney before you adopt a policy separating sports based on biological sex. The last thing I wanted to mention is this executive order. Again, I teased it a couple slides ago. We use the definitions from this executive order in our model policy, but I do want schools to know this. At least for the next 2.5 years here, the current administration has decided that if your school does not separate sports, bathrooms, and locker rooms by biological sex, you are at risk of being investigated by the Office of Civil Rights under the Department of Education. I have a couple examples on the screen here of different situations where the Department of Education has opened investigations into school districts for Title IX violations. And these range again from allowing biological men on women's sports teams to allowing them in locker rooms to allowing them in bathrooms. You'll see that New Richmond case is the one on the very bottom there. U.S. Department of Education initiates Title IX investigation into Wisconsin school district, that's New Richmond, over alleged use of women's restrooms by biological men. So this is something that schools need to be aware of, that if you don't separate sports, or if you take the position that you're not going to and you will allow um, trans women or biological men to participate in female sports, you are at risk of being investigated by the Office of Civil Rights, and they are doing it. It's not a hypothetical threat. This is something that they are actively opening investigations into. And just recently, this past month, there was an interagency agreement between the Department of Education and the Department of Justice, which allows the Department of Justice to also look into these Title IX complaints. So there's more attorneys and more eyes on these complaints. So even if the school decides that they're not going to, or if they're going to take the opposite approach that, the Supreme Court said this was a may, not a must, so we're going to allow transgender athletes on biological women's sports teams, that's something that could result in an investigation from the Trump administration's Department of Education and the Office of Civil Rights, or like I mentioned, the DOJ. So I just want schools to be aware of that as an additional legal risk if they decide not to adopt a policy like Will's model policy. So with that, I'm going to open it up for some questions. Ooh, I don't even know how I did that. But anyway, I'm going to open it up for some questions. I see we have a couple in here. Um, so you mentioned bathrooms and locker rooms. What about accommodations on overnight field trips? Dan, do you want to go ahead and answer that question?
Yeah, I think that this is probably the strongest position a school could take is to segregate accommodations on field trips. And the reason why is because Title IX itself says that nothing in this uh, law shall be construed to prohibit any educational institution from maintaining separate living facilities for different sexes. So Title IX itself, when it was passed, that's 20 USC 1686. So Title IX, when it was passed, specifically included a provision to separate sexes for accommodation purposes, like dorm rooms, and this certainly would apply to overnight field trips and things like that. The interests also under the Constitution would be similar, the interest in safety. And I think that there is a compelling safety interest for girls who are traveling overnight on field trips. So I think that's pretty much a no-brainer to me, is that this decision would extend to overnight accommodations.
I did also just put our contact slide up on the screen, so you should be able to see our email addresses there, or you can always go to will-law.org and fill out our contact and attorney form. So while we're answering these questions, I just wanted that available for anybody who is interested in contacting us. Um, so one of the questions, and actually, I think two of the questions are very specifically about these anti-discrimination laws, and whether or not these state laws would stand up against the Supreme Court decision. That is an open question. As far as I'm aware, there hasn't been a case that has been brought specifically on that state law anti-discrimination section that would specifically answer that question. But I do think that it's a worthwhile question to ask, which is why I mentioned you should contact your school attorney or contact us. because it does seem to be a deterrent for a lot of school districts at this point. Well, my state has an anti-discrimination law that says I can't discriminate based on gender identity. Therefore, I'm not going to adopt a policy like this. But as I mentioned, if your school continues to allow biological men to compete on women's sports or go in their bathrooms, go in their locker rooms, then you're also at risk of being investigated by the Office of Civil Rights. So it doesn't put schools in a very easy position at this point, and we recognize that and sympathize with that. But it is a question that you should continue to ask either to us directly, and again, our contact information is on the screen, or to your school board attorney specifically.
Yeah,
Um,
there are there's two cases, there's two questions about athletic associations that still allow for transgender athletes. One question's about Connecticut and one is about Minnesota. And what I would say to that is that the sports the sports associations are going in the way of the BPJ case. So the International Olympic Committee, the NCAA, all moved towards sports based on biological sex during the context of this case. I think a lot of state associations are doing the same. They're moving in that direction, but still, as of today, a state athletic association can allow transgender athletes to participate on opposite sex teams. So what is going to need to happen in those places like Connecticut and Minnesota is that a plaintiff, a girl, is going to have to bring a lawsuit against the district and say, you are discriminating against me based on my sex because you're forcing me to participate against boys. And the boys are not having to deal with this issue. They don't have to deal with the safety issue and the competitive disadvantage issue and the privacy issue. But me as a girl, I have to deal with those issues. So therefore, it is sex discrimination to allow boys on my girls' teams. And you can see, there's any number of videos out there showing the extreme danger posed to girls in especially sports like volleyball and lacrosse and soccer, in which girls can get seriously injured when a boy is participating on the field with them. And the Title IX inquiry in the equal protection inquiry is, are girls and boys being treated differently? And if so, what is the reason? And it seems very clear to us that when girls are forced to bear the burden of this transgender policy, that girls are being treated differently. When girls are the ones who have to bear the burden of the competitive disadvantage, the safety, and the privacy risk, the girls are being discriminated against. Boys are not having to deal with those issues. So that under Title IX and under the Equal Protection Clause is sex discrimination. But someone will have to bring those cases. Those cases will have to be brought separately by girls and parents willing to stand up for their kids in those courts.
yeah. There's a question that says, aren't there states that allow the original birth certificate to show something other than biological sex? In this case, the birth certificate would not be changed. So if there's a situation where a birth certificate has been altered in some capacity to say something other than biological sex, which again could be the case in your state, then that document under our model policy would not be allowed to be produced to demonstrate biological sex. So it's drafted in a way that says if that biological marker, if that sex marker on the birth certificate does not correspond with biological sex, they cannot produce the birth certificate as documentation that they are a biological female or a biological male. But that is a consideration, this whole debate about birth certificates and whether or not they can be changed and how they're changed is certainly something that has been talked about a lot in state legislatures as these laws have been passed. Some of the laws on the state some of the state laws that I had on the slide, um, talking about those 27 states, um, they specifically mention birth certificates and that birth certificate will be used. And in those states, I'm not sure whether or not birth certificates are allowed to be changed, specifically the sex marker on birth certificates. But many of them don't say anything about birth certificates, so other documentation can also be used. But that's a good flag as well. You should always check your state law and consult with your school board attorney to make sure that everything in the policy corresponds with your state policy. We have another question about state law versus federal law, which is a fun legal question that we get to answer every once in a while. The question is, doesn't state law override federal law? No, state law does not override federal law. Federal law controls, although states are allowed to take it further than what federal law says. So if there is a federal law that kind of gives the broad strokes, okay, you have to do this, states can pass more specific laws under that to make it stricter, depending on what the topic is. But in the present situation, if we have federal law, Title IX, that says that you may separate sports teams based on biological sex, a state law prohibiting that separation would be something that's ripe for a legal challenge. And again, you should consult with your state attorney on that.
Yeah, and I would just add that as of today, um, Title IX and the Equal Protection Clause have not been interpreted uh, to require sex separation. So if a state is allowing, like Minnesota or California, allowing these transgender athletes to participate on the wrong teams, as of right now, there's not a Supreme Court case that says that you can't do that. And so these state laws are not, in fact, overriding federal law as of today. That's why it's important to bring new cases to change that and make sure the U.S. Supreme Court actually recognizes that separation is required in certain circumstances. It's not just permissive.
Yeah, that's a good flag. Um, we do have a question about intersex individuals or situations where there's chromosomal abnormalities or the gender isn't super clear. This is something that affects a very, very, very small percentage of the population, but is also why we included a dispute resolution process in our model policy. If there are situations where it isn't as binary, which again is like 0.00001% of the population, so hopefully your school district will never have to deal with a situation like this. But if they do, then we have this dispute resolution process where the school can examine medical records, the birth certificate, talk to the athlete, talk to the parents, talk to the coaches, consider the privacy of other students, consider the safety of other students, and make a determination based on eligibility in that way. So that was another reason why having a dispute resolution process was important in this model policy. So if you do adopt our policy or something similar to it, then you have kind of that safeguard in there to address some of those situations that are very rare but could occur. Sorry, I'm just reading through some of the other questions.
Yeah, that last one about Oregon, that's right. The current Oregon Department of Education directs schools to allow transgender athletes. And the question is, so Oregon boards are still constrained until they must resolve the question. We can't give advice about what's going on in Oregon, but you should ask your attorneys. But yeah, if there is a state law or state policy that currently mandates that this should be going on, you're going to have to follow your state law. I've just confirmed that that actually is the case by getting guidance from a local attorney.
I would also, again, talk to your attorney about the legal risks of an investigation from the OCR. So, again, schools in these states are in a really tough position if they have to follow state law, but they are still very much at risk of being investigated by the Office of Civil Rights. If they do follow state law, it just puts them in a really terrible position. So, that's something also to talk to your attorney about. What are the legal risks here, and the liability, for your particular school district?
Yeah, I would. So, one of the things, just to put a point on that, and wrap it up here, um, to the 23 states or more that are still permitting this to go on. If this is affecting you or your daughter, um, or about a friend with this issue, there's not many excuses not to take action because um, we have to be assertive and assert the rights of these girls who are being discriminated against. If you are concerned about the publicity of a lawsuit, you can do what happened here. A B.P.J. was for most of the litigation just initials. And the cases here in Wisconsin are by Jane Doe's or acronyms. The courts allow high school girls to use pseudonyms or initials, so you don't have to be public if you don't want to. And also firms like Wisconsin Institute for Law and Liberty, we represent clients pro bono. One of the cases brought in this B.P.J. case was one of the parties represented by the Alliance Defending Freedom. They also represent people pro bono. So there's lots of pro bono help out there that you can be anonymous. And if we don't assert our rights of our girls, these girls in these other states are going to be stuck, and it could be years.
Yeah. Um, will answer one more question. But Dan's comment wrapped it up very nicely. So again, please consider um, really taking care of the women and girls in your schools, or bringing some of these cases. Contact us, contact your school board attorneys, to talk about resolving some of this tension and this conflict. Last question: what do we do if we play a team from another state that allows biological males on female teams? That's a great question. If you play another team that does allow biological males, your team will have to make a determination about the safety and privacy of the girls on your team and whether or not you want to participate. Unfortunately, there was a lot of news stories out of the last few years where teams were forfeiting, because they didn't want to risk the safety and privacy of their student athletes, their women, and their girls, to play against a biological male. We've seen, and Dan mentioned it earlier, there are some pretty horrific cases of injuries that come from that. So you'll have to make a determination, on a case-by-case basis about what's best, whether or not your team participates against those teams or not at this time.
And I would add a lot. The reason why sports is so important in high school and beyond is that it's not because our kids are going to go become professional athletes. It's a very small percentage of people that actually would make a living out of sport. But the idea is that you are ingrained with certain character traits and attributes, and you learn certain values. And if the value that you're learning is that your team has decided to forfeit a game based on a principle, that is a significant learning experience for your daughter. And so a lot of the things that kids deal with in sports, not only teamwork, but character issues and discipline and hard work. And this issue just presents one more component that can be a learning exercise. And I would say if I had a daughter that was forced to participate, on another team from another state or a team that presented a safety risk or a danger, that would be a very good learning experience for the girls on that team to communicate and decide how they're going to deal with their own rights and their own values and how parents are going to guide them in that decision. So I think it presents quite an important learning exercise.
Thank you all for joining us today and for discussing this topic. I know that going into the upcoming school year, it's important for you all to have your arms around what the laws are, and to decide what to do for this upcoming school year. We encourage you to reach out to us if you have any additional questions, and please watch out for that model policy. We will be sending a link, in a follow-up to this webinar if you registered. So again, thank you so much and enjoy the rest of your day.
Thank you.